Good morning, and may it please the court. My name is Bob Young. I represent the public defender of the 10th Judicial Circuit, who's joined me here today. And I want to thank him. On behalf of him, I want to thank you for considering this important matter. I believe this is the first time it's actually been argued by live lawyers in an adversarial situation before a court.
Has it been argued by dead lawyers before?
Considering the subject matter, that's not, never mind. The situation is extremely important, as I'm sure you can understand, to the 20 elected public defenders in the state. It's important to the 405 guys who woke up on death row this morning, but mostly it's important to the jurisprudence of Florida. And it is an argument that in the history of Florida, I don't think has been presented in a court, at least in this fashion, even though the principles upon which it's based, the overarching fundamental principles, are as old as the Republic itself. The separation of powers is an important concept unique to American government, or it was at the time. And it's something that the Supreme Court of Florida has said at every opportunity is a bright line of separation, a strict separation, a wall of separation, unlike the federal system where it's sort of penumbral or entanglements, unnecessary entanglements. I'd like to get right to the merits, which I think are important, but if the court has any concerns or questions about jurisdiction, I want to...
Well, we probably do, but let's do the merits first, and then we'll come back to jurisdiction.
All right.
And it seems to me that there's a statute, and I'm looking for the number on it. It's like 27.5303 or something along those lines, that I think expressly states that the public defender can be appointed for purposes of this clemency.
There are three statutes, Your Honor.
But that's the one. There's one of them that's a little more direct than the other. That was.
It is, except that the section that's in, and I have it here, is a section labeled conflicts. The title of the statute is the conflicts, and there certainly isn't a conflict, at least at this stage yet. But the other statute, the one that does apply across the board, says that the circuit court retains the power to appoint, whatever that might mean. But the affidavits of both two long-serving public defenders in the Fifth Circuit and in the 10th Circuit, as recited in the Babb opinion, state that that's never happened in their experience. And what has happened in this case, and to a much greater extent in the last 10 days, 10 times greater than the history of Florida, is that public defenders all over the state have been appointed. So the judge that considered this...
Do we have to declare those statutes unconstitutional if we reach the merits of this?
That's certainly... I think the Solicitor General would suggest that the statutes empower the courts to do that, and therefore, since the courts have acted pursuant to those statutes, then the statutes themselves have to violate the...
If we declare the statute unconstitutional, and these people do need counsel at a clemency hearing, who's supposed to appoint it?
Well, I think I can answer that question for you, although it isn't our job to grease the mechanism of death. But most people who are familiar with this area would think that the most efficient way would be that the lawyers in the regional, the collateral CCRC office would be the most important, most appropriate to do that. They are people who've handled the case from the beginning, who know the facts, and do that kind of work routinely. There are other ways it could be done, but the point of it all is that executive clemency is a function of the executive branch of government exclusively, and in a case decided by the Florida Supreme Court.
You don't want to have the governor appointing this man's counsel. I mean,
well, that was one of the versions.
It seems to me that there's not much entanglement if the only thing a circuit court judge is doing is appointing a lawyer. I mean, it could be the chief judge in Leon County, I suppose, could do this, but is...
That's exactly, you've hit the nail right on the head, and that's the problem, is that most people, because death is different, see the appointment of clemency counsel, which is only required by the rules of executive clemency, as so minor in the scheme of things that it's not an intrusion into the judiciary to ask them to do that. And if you see the circuit judge's function as a rubber stamp for the request of the governor, the ex parte request of the governor, then that may be true. But judges have inherent, and the best way to see how much of an entanglement or how much of a real constitutional problem it is to consider for a second what would happen if the judge actually exercised in her inherent authority to decide, her inherent discretion, or the discretion imposed by the statute, as the Solicitor General has pointed out. And so instead of stamping the governor's letter granted, what if that judge set a hearing and had the defendant come from death row and considered the defendant's wishes? This is a lawyer put on the defendant without asking or checking for solvency or determining whether the person already has a lawyer, which in this case, and I think in almost every other case, they did because of the 3853 process.
Mr. Davey at least is not here objecting to you being his lawyer.
Not yet, but he hasn't had a chance to.
He's a party to this proceeding. I'm not sure whether he's entitled to counsel in this proceeding, but he's a party to this proceeding.
He absolutely is a party. The judge entered the order ex parte without any opportunity for input from him or his lawyer, or without notice to him or his lawyer, even though the governor, who is a lawyer...
But he has not objected to that, pro se or through a lawyer.
That's correct.
The truth is, this is more a budgetary issue than anything else. People are worried about who's going to pay for these lawyers, right?
No, that's not right. It is a budgetary issue, but it's not only a budgetary issue, and it's certainly not mostly a budgetary issue. What is true, though, is and it may help to think about it as if the judge who appointed him really did have a hearing and really did see what Mr. Davis wanted to do. And eventually, considering all the factors and whatever, maybe applying Nelson, maybe applying Ferretta, said no. I'm exercising my discretion and not appointing a lawyer.
And forgive me, but I saw the order this morning, but I don't remember. Did it appoint a specific public defender or simply the public defender of the 10th Judicial Circuit?
10th Judicial Circuit.
So,
and that's true in the dozen cases that have happened in the last few days. If the judge says no, then you have either a constitutional crisis that the executive can't perform its function because it has to have a lawyer under its own rules, or maybe the executive could come to this court and say the judge abused his discretion by saying no. Our rules say clearly he has to have a lawyer. The judge failed to follow the rules of the executive branch and therefore has abused the judge's discretion, even though the executive branch rules were passed by 3 people without any APA review.
In a number of these that have been coming up, has there been a scenario where a trial judge has said no?
They've never come up before, despite the brief of the Solicitor General that the Supreme Court finds that it happens all the time. The sworn testimony in this case and in Babb was that no, in the last 30 years, no public defender has ever been appointed. So this is a new phenomenon, even though the concepts are very old. And what you're saying is, by authorizing it or not finding that the statutes that authorize it are unconstitutional, is it's okay for the judiciary to dabble in the field of executive clemency, or vice versa. It's okay for the executive to ask the judge to appoint a lawyer. There's some...
let's assume a very clean case. The PD is appointed, end of court's involvement. The lawyer is then going to be operating under the rules of executive clemency, correct?
Yes, sir.
And I think we would agree whether to extend clemency is purely a matter of grace controlled by the executive.
Yes, sir.
So as this is teed up, can we say beyond speculation that this parade of horribles of entanglement is anything other than speculation?
Well, that's the sort of the potted plant approach to judging, and you expect that the judge will not be further involved except by rubber stamping the ex parte request of the governor. But what's likely to happen is that lawyer is going to want to get paid. And your opinion in Dayton, and reaffirmed by the Supreme in Ramada, is that your job to authorize extra money is to ensure a quality representation, whatever that may be in the clemency context. And that lawyer is going to want an investigator and probably an expert. And all of those things then fall to the judiciary to decide. And that doesn't even consider the fact that in the capital litigation, those cases are very carefully choreographed by the state attorney and the defense bar and the judge who's in the capital division, because they're long cases, they're complicated cases, and they involve a lot of jurors and a lot of witnesses. So there's a conveyor that makes sure that no side resources are overtaxed, and they're scheduled in that way. And then these other cases are dropped in there by the governor and by the rubber stamp of the judge.
So I'm assuming within the clemency rules that there is nothing that dictates how a PD is going to be compensated or how experts are going to be compensated.
That's correct.
Well, so from the PD's standpoint, this is purely not purely, but it is a budget concern that impacts the current operating budget of the PD for the 10th Circuit.
It certainly does do that, but it has much more dimension to it than that, not to mention the constitutional dimension that's fundamental to our democracy.
Well, the PD is a creature of the legislature, isn't that correct?
Well, it's a constitutional office whose duties are set by the legislature, yes, sir.
And part of the duties have been set in two different statutes addressing that the court can appoint the PD in the clemency. And so shouldn't the PD include that in the budgetary request to the legislature, that we have this responsibility?
It should this week, after the last 16 cases have been assigned to public defenders in the last 10 days or so, yes, sir. But unfortunately, the legislature's gone home.
But you keep bringing up these cases which are probably not in the record, but
they're not.
Are there other proceedings that, we do have a jurisdictional issue here we're going to have to get to. Are there other proceedings that are going to be challenged in some fashion?
I don't know. Regional counsel is here. They have two that I know of in this region. They may have more than that.
Has your office been appointed recently to more of these?
Not that I'm aware of. I don't believe so. The question of Judge Gellin.
When a request comes out for clemency counsel here, is in this case Mr. Davey? Is he currently represented in other proceedings by some from Capital Collateral?
Yes. Now, whether those proceedings are pending or not, I can't tell you, but they are certainly his lawyer. They're in touch with him. We've talked to them. He had a lawyer.
The appointment took place without anyone filing a motion and without any hearing.
That's exactly correct. And so did all the others.
Is it a letter or a telephone call? How is the 10th Judicial Circuit being informed that there's a need for appointment?
Well, that's a good question. And in a busy law office, any busy law office, hundreds of papers come in every day. And those papers go to an entry-level person who associates them with the file and takes those files to the lawyers who handle them. And those papers are in a public defender's office, a good chunk of them, dozens of them, orders appointing the public defender. But when a paper comes in the stream of commerce, in the stream of paper flow, that appoints the office in a case that's been closed for 17 years, and the file is in some warehouse, it's hard to...
I was going to ask you about that as well, and so I'll interrupt you right now, that there are no pending post-conviction proceedings in Polk County as to this man?
As to this man, no, sir.
So the file was literally a closed file with no activity going on?
Absolutely.
Okay.
So it would go to the lawyer who last touched the file, which would be an appellate lawyer, and with all due respect, they would study it and ponder it and analyze it, and then eventually it would find its way to the capital division. And so it literally drops out of the 10th floor or the 8th floor, or wherever we are, down to us with no notice of any kind at all. And it's that event that the Solicitor General would tell you triggers the 30-day window, and I don't mean to get ahead of the jurisdiction, and I won't if you want to keep talking about this. But so it's as they would characterize it, the rendition of that order starts the 30-day clock ticking, and there is no way around that. It seems to us much more like a person who is a judgment debtor in a judgment that they don't know about.
Your first notice on this as a public defender is when you receive the order of appointment?
That's correct. And I think that's routine. But that's only that's an issue about jurisdiction. But to Judge Gallen's question, the fact that the duties of the public defender are, I'm not sure set is correct, because they are oblique references. The references don't quite fit. They talk about conflicts. And historically, as the brief points out, I think it's remnants of other languages when the courts appointed private lawyers in all capital cases back in the 30s. But the fact that those orders, those statutes convey some authority for the public defender to do this work doesn't mean that the legislature can confer on the trial court the duty of appointing lawyers in cases that aren't in the trial court. Lawyers are appointed these days not by judges, as is suggested by the Solicitor General, but by the clerks. And all of the court appointments are by the clerk. Now, the judge can unappoint us. There's some question about whether the judge can appoint us when the clerk is found not to appoint us. There's some legal question about whether it can happen.
Clerk does it when it's a traditional criminal proceeding.
That's correct. And so the idea that only a judge...
I have to read the statute, but the statute contemplates the court appointment. Is that right?
I guess it says the court retains the power to appoint. Retains from where is a good question, but that's what it says. And then the language from the other sections, the conflict section, says the public defender or other attorney may be appointed by the court.
Okay, we're about 12 minutes into this, so why don't we back up and talk about jurisdiction a little bit?
Yes, thank you.
How can we review this by cert at this point in time?
Well, you can because you have to.
Cert's discretionary, by the way.
Well, there is a good point. But what the Solicitor General would suggest is that there is a time limit for asking a court to vacate an order that was entered without notice or hearing and without jurisdiction. There simply is no time limit for asking the circuit court to do that. And so their position here today is that when we got that notice, however it was delivered, whenever it was delivered, how many days of mail it took, the 30 days started from the rendition of that order and isn't extended by any ex parte fashion. You know, it could have been the product of a hearing. The chief legal officer, the chief law enforcement officer of the state, who is the governor, could have asked the state attorney to file a motion and could have invited us to court to have a hearing, and we could present some of these arguments to the court. And then that order, the entry of that order, would certainly trigger the 30-day time limit. But an ex parte order that drops out of the sky, the first thing you should do is ask the trial court to vacate it, and there's no time limit for that. And as soon as we did ask, and the trial court said no, again, not ex parte, but without a hearing, we came here. Now, I think the Solicitor General will argue that our attempt to convey or convince you to accept the prohibition jurisdiction earlier somehow was an adjudication on the merits by this court that the 30-day time limit had already run. That certainly doesn't seem to be the legal effect of this court's order. And of course, Babb versus State, which we lose on the facts of, we win on the jurisdiction of. And our view then and now was that this order is very much like an order denying speedy trial discharge, or denying disqualification of a judge, or denying immunity of all sorts. It's the kind of thing that could be handled by prohibition, because the judicial labors continue on after the order appointing the lawyer is entered. So whether it's prohibition or whether it's certiorari, we're well within by weeks within the time limit from from seeking cert for the decision to vacate the order, which was denied by the trial court without a hearing. So what happened was, we asked the trial court to vacate its order. There is no time limit for asking for that. When it didn't vacate its order, we flew here for justice. So it seems clear to us, at least, that there are no time bars to this. The case is more like a judgment debtor who is improperly served and then finds out that there is a judgment against them. Certainly, the Solicitor General, I think, would not argue that the time, you only have 30 days to appeal from the judgment that was entered when you weren't given notice of it in the first place. And likewise, that shouldn't be the case here.
Okay.
Thank you.
I'll save you 5 minutes for rebuttal.
Good morning, and may it please the court. I'm Alan Windsor on behalf of the state of Florida. I'd like to start with the jurisdictional issue because it is a threshold issue.
You know,
the underlying order.
Before you get completely
Yes, sir.
started on that, so I'll distract you a little bit. Who do you represent?
I represent the state of Florida.
The whole state of Florida?
I do, Your Honor. I work for the Attorney General.
I understand.
Yes, sir.
I understand who you work for, but
Yes, sir.
in this case, I'm just sort of.
The style is Demick versus the state of Florida, but I'm a little uncomfortable, given the separation of powers arguments and all that, as to who we should actually, do you represent the people of the state of Florida in this or not?
I do, Your Honor. The Florida Supreme Court in Rometta said that clemency is a purely executive function, but it's still an outshoot of the overall criminal justice system.
Is anyone representing the defendant in this case?
In this certiorari proceeding? No, sir, not to my
Is he entitled
knowledge.
to counsel in this case?
I'm sorry?
Is he entitled to counsel in this proceeding?
As a constitutional matter? I don't think so, Your Honor, because what this court is faced with is the public defender's argument that the legislature's authorizing the circuit court to appoint this particular lawyer violates the Constitution. And so as on behalf of the state of Florida, we're here to defend the constitutionality of the legislature's action in giving that authority to the circuit courts.
Okay.
On the jurisdictional issue, the order that this court is being asked to review is the original appointment order. And after the original appointment order was issued, the petitioner came to this court and asked the court...
The appointment order was issued without a motion?
That's correct, Your Honor.
Was it issued with notice to either the public defender or to Mr. Davey?
Well, the order was served on the public defender and Mr. Davey.
What was the hearing for the appointment?
My understanding is there was no hearing on the...
Because there was no motion.
That's right. The Chief Judge was responding to a request of the Office of Clemency to appoint counsel. And that's in the record here.
So without a hearing, without a motion, without notice, or the normal forms of due process, an order was placed in a closed file. Was it rendered?
The order was rendered, and the order was served on the public defender.
How was it rendered?
I'm sorry?
How was it rendered?
It was rendered by being put in the court file.
In a closed file?
Well, I don't know the mechanics of what happened in the clerk's office, Your Honor, but I don't think there's any dispute that the order was issued and served on the public defender. And if there were any suggestions that that violated due process, the time to raise those was when that order was issued.
Why wasn't the time when they did it by filing a motion to quash it?
Because the motion to quash it was based on the same, there was nothing to the motion to quash beyond the same arguments they presented the first time around, which was that the court didn't have authority in the first place.
Did the court ever get jurisdiction over them?
I'm sorry?
We have a closed court file.
Okay.
That would seemingly have jurisdiction over no one at that point in time. I mean, why isn't this a void order?
Well, it's not a void order because the circuit court has the authority, as given it to it by the legislature, to appoint counsel in clemency proceedings.
So
And that's what it's
It
done.
would be void unless if the statute is unconstitutional, but I mean, to some degree, this runs in circles around whether this statute is constitutional or not.
Well, I think a big part of this case hinges on whether the statute is constitutional, and it is constitutional. But any time a court issues an order that's beyond its jurisdiction, which would be the argument here, that the circuit court in the first instance didn't have jurisdiction to issue the order, and we don't dispute that certiorari is the correct mechanism to challenge that, but there's a time limit on certiorari. And so, and they missed that time limit.
Why would they, if it's a void order, why would they have any obligation to obey it at all?
Well, I think you have an obligation to obey an order of a circuit court unless you don't get to decide whether the order of the circuit court as a party is void or not. That's what this court is for.
The public defender is not a party to the proceeding in which this is a closed file that an order is put in. I don't think that they're representing anyone in that case at that point in time. And so without some form of service or notice to them, I'm not 100% convinced that the court had jurisdiction over them to do this.
Well, two responses to that, Your Honor. One, I don't think there's any dispute that they were served with the order and that they had the order. And if it were misplaced, then that's frankly not an issue that...
But they weren't served with a motion. They weren't given notice of an impending court action. They were given no opportunity to object. Mr. Davey was given no opportunity to tell them whether or not he even wants them as his lawyer, from all we can tell.
Fair enough, Your Honor. And if a party receives an order that it believes was not properly issued, then it can go and revisit that with the court, and it can ultimately seek review here, which is exactly what they did, albeit too late. And so the very same issue that we're all talking about here, which is whether the circuit court was authorized to issue this order, came to this court once before on a writ of prohibition. This court's order was that writ of prohibition was not appropriate.
Because the action had already taken place.
That's correct. But under the rules of appellate procedure...
We didn't decide whether the action was void. We just
That's correct.
concluded that particular writ was not a correct writ.
That's correct. But what the court would do in the ordinary course is treat the incorrect writ as the correct writ, and what this court said in the order was that it couldn't treat this as a writ of certiorari because it wasn't timely filed. And the timeliness of a certiorari petition is a jurisdictional issue. And so we cited in our brief a number of cases where parties have done, albeit in different circumstances, exactly what we have here. They've tried to restart the jurisdictional clock by going back and asking the circuit court to essentially reissue the same order or revisit its old order with nothing changing in the interim. You could conceivably have a situation where something changes that makes the legal inquiry different, but the petition here is exactly the same as the issues that were presented in the prior.
If your position prevails, there's absolutely no avenue for the PD to challenge the constitutionality of the statute or this particular appointment?
Well, again, with respect to this particular appointment, we don't contest that certiorari is an appropriate vehicle, and so the time to do that, though, would be within 30 days, which is when the jurisdiction...
There's no independent action?
I don't know that they couldn't have a deck action or something like that. I don't know the answer to that. But
It's ongoing representation, so could this be handled in a deck action?
I'm sorry?
It says it's ongoing representation.
Your Honor, I wasn't talking about this case. I understood the question to mean as a general matter, can they see?
Did they file an action for declaratory relief that brought in, I'm not quite sure, the state and challenge the statute through that?
I don't think so, because I think the avenue here was to petition for certiorari and to do it in a timely way.
So if they've been appointed under an unconstitutional law and they don't object to it in the first 30 days, they must do that which is unconstitutional to the end?
I think with respect to any order of a court ordering any person to do anything, if the person believes it's not a constitutional order, their remedy is to go to the appellate courts and not to just unilaterally decide.
Even if it's a void order?
I'm sorry?
Even if it's a void order?
I think so.
Okay.
But if it's a void order and I go back to the trial court and I judge, here's a motion for reconsideration, motion for rehearing, motion to vacate, call it whatever you want, and the trial court gets it wrong and refuses to vacate a void order, your position is, in this situation, too bad, PD, you can't challenge that. So it's unreviewable?
No, it's not. It's not unreviewable at all. The issue is the arguments that were presented to the circuit court were the same arguments that were presented to this court once before in an untimely petition. And so if the rule becomes, well, you can defeat the jurisdictional time limit by going back and asking the trial court to reconsider and raising the same defects or the same arguments that you did before, then you lose the time limit altogether. But on the merits of the case, Your Honor, we are here on certiorari review.
I don't really
Yes.
understand procedurally why, I mean, the governor and is it two members of the cabinet sit as the clemency board? Or
The entire cabinet is the clemency,
The entire
but the
cabinet is-
governor has special role within that.
And so why doesn't the clemency board file a motion in the circuit where someone that's on death row it had their initial trial and ask the court pursuant to the statute to appoint counsel? That's notice and due process. And so I'm not, what's concerning me more than anything else, I think, is the whole due process issue here, is that the clemency board is not asking in any normal legal fashion for appointment of counsel.
Well, the clemency is asking the chief judge to appoint counsel. It's not asking for a particular lawyer or a particular counsel. So it wouldn't be.
But they're not doing it. They're not doing it in any way that's normal to due process procedure.
But due process to whom? To the condemned inmate or to the?
Navy, number one.
Okay.
He has some say, I would think, in whether someone represents him.
Well, the governor's asked the circuit court to appoint counsel, and then it's up to the circuit court to the.
What if the governor? I mean, what if the circuit judge decides to appoint me?
Well, I think.
Or you? Okay.
Uh-huh.
Can they do that?
I'm sorry?
They can do that, right?
If the circuit court entered an order against an attorney who thought it was beyond the circuit court's jurisdiction, then that attorney would certainly have a review.
And one of his arguments would be that no motion was served on me. I had no opportunity to object, participate, and I've been violated in due process, right?
Perhaps. Perhaps.
But your point is that all those are arguments that should have been brought up within a timely cert petition.
That's correct, Your Honor.
And having failed that, tough.
Well, I wouldn't say tough. I would say having failed that, this court doesn't have jurisdiction to consider a certiorari writ. But if it does, I think that, if the court determines that it has jurisdiction to resolve this issue, we are here on certiorari, which is not a review of simple legal error. It takes more than simple legal error for this court to grant the writ. And so to the extent that these issues are things that...
A violation of due process.
I'm sorry?
A violation of due process will work, however. For certiorari.
Well, it would have the circuit court...
Violation of due process is a departure from the essential requirements of the law, is it not?
That's right. But the issue about whether the trial court in appointing counsel here relied on a law that was unconstitutional, which is, as I understand the essence of their argument, that the legislature violated separation of powers by authorizing the circuit court to appoint counsel in these cases. To the extent that's never been argued before or never been presented anywhere before, as I understood the petitioner's argument, that would speak to the denial of certiorari relief, because the circuit court certainly couldn't have been violating clearly established law if it was operating in an area that hadn't been resolved. In fact, it has been resolved, though, because this court's sister court in the 5th DCA has ruled on these exact issues in the Babb decision last year. And in fact, the circuit court was operating and was required to follow that as binding precedent, because this court hasn't ruled on that issue. So the constitutionality of the legislature's authority, given the circuit court's authority to appoint counsel in clemency cases, we believe, is certainly valid. And as Your Honor pointed out, the Office of the Public Defender its duties are determined by the legislature, and that includes what types of cases the public defender will handle. And so for decades, this has been the practice, where circuit courts appoint counsel in clemency proceedings.
So does the record support that? I mean, is that accurate?
And I said counsel,
It's
not...
been going on for decades?
The appointment of counsel, absolutely, Your Honor. The issue, the separate issue that they've raised here is that, well, the public defender is a new thing. Appointing the public defender is a new thing. That's
This appears to be unique to the extent we are now having requests made to the public defender.
well, they have an affidavit saying that that hasn't happened before. The Remetta decision from 1989, the Florida Supreme Court said it was the common practice. But either whether it's common or
One
not,
way or the other, there's nothing in this record to show us how this governor or prior governors in the past 30 years have obtained counsel for clemency hearings.
the only evidence in that regard in this record, Your Honor, is the affidavit of the public defender.
Okay.
But again, you have the Remetta decision saying it's common. Whether it's common or not, it's authorized by statute. And whether the separation of powers issue, Your Honor, doesn't depend on whether it's the public defender or whether it's private counsel or whether it's anyone else. The separation of powers argument is that the court is unduly intruding on the executive's clemency function. And that would be the same whether it's the public defender or anyone else. And that's in fact not the case. Courts have said over and over again that the clemency is a purely executive function that can't be interfered with by the courts, and that's correct. But during the same time it's been saying that for decades, it's been recognizing that circuit courts appoint counsel to participate in these. So the only logical takeaway from that is that the simple appointment of counsel doesn't interfere with the clemency, doesn't intrude on the executive's power in clemency. The circuit court is certainly not saying to the executive, here's how you have to do clemency, here's the evidence you should consider, here's the timeline, or ultimately here's the decision you should make. Instead, they're simply saying, here's a lawyer who's going to assist and advise the appellate, the clemency applicant.
Well, suppose appointed counsel then has some concerns as to how a clemency hearing is run. To the extent that lawyer wants to bring those concerns to the circuit court, can he or she? But at that point, do I have some sort of entanglement between the judicial system overseeing how a clemency proceeding is going to operate?
The circuit court certainly cannot direct how the clemency proceeding is going to go forward. That's clear. I think we all agree on that. And so if you had an attorney in the clemency proceeding go into circuit court and say, I don't like the way the governor's doing this, or I don't think they're considering this correctly, that would not be an appropriate thing, and the circuit court would have absolutely no authority to order the executive to do anything with respect to clemency.
The clemency hearings are all held in Tallahassee?
I'm sorry?
The clemency hearings are all held in Tallahassee?
I don't know, Your Honor. The statute, though, to the extent Your Honor is going to whether it should be a court in Tallahassee doing it, the statutes...
Actually, no. The
Okay.
statute says that there's retained jurisdiction in the trial court from the initial trial.
That's right.
I'm just kind of wondering whether the trial judges should be appointing Nancy Daniels rather than Mr. Dimming if it's going to be for a hearing in Tallahassee.
Well, one of the statutes talks about the court who imposed the death sentence in the first place, so we believe it's appropriate for this court to appoint counsel.
But can he appoint any public defender?
I'm sorry?
Can he appoint any public defender?
Can the circuit court appoint a public defender that
Say he,
didn't...
because I believe it was a
Male judge here, but
Can he appoint a public defender that's outside of the, that didn't prosecute, that didn't... well, it would have to be, I believe it would have to be the judge who in the court that imposed the
because
death
unless
sentence.
the governor and the cabinet's moving all over the state, it'd make more sense to just have Nancy Daniels appointed to do all of it.
I don't know if he could or not. You might have some jurisdictional issues there, but I don't know. But again, those are things the legislature could change if it determined that was appropriate. But what the legislature has done is given the circuit courts the authority to appoint the attorneys that it feels are appropriate to appoint. And again, these exact same constitutional issues were presented to the 5th DCA just last year, and the 5th DCA found there was no entanglement, there was no interference with clemency.
The state wasn't even called upon to issue to file a response in that case?
I don't know the answer to that question, Your Honor. In the Babb case,
Yes.
I don't know if the state
What's the opinion show? I don't.
filed a
For
response.
some reason, I had the impression that the state did not even appear for a response in BAP.
I don't know. I don't know that the opinion indicates that. It's a published opinion. It's several pages.
It will one way or the other. It's either going to show an appearance or no appearance.
In the opinion?
Sure. Should.
Your Honor, the opinion indicates no appearance for respondent. So, nonetheless, that was a decision of the 5th DCA. It was binding on the circuit court in this case. The circuit court did not have the authority to find, in light of that the legislature's action was unconstitutional. And so, by following that decision, the trial court certainly didn't depart from the essential requirements of law in determining that the process that the legislature has in place was unconstitutional. We would ask, if the court doesn't have any further questions, I would ask that the court dismiss for lack of jurisdiction and, in the alternative, deny the petition on the merits.
Thank you. Mr. Young?
Thank you, Your Honor. I only want to clear up a couple of things, although I do want to observe that the conversation that has been going on shows the extent to which the trial courts are inextricably involved in the clemency process once this slippery slope is started. The one thing I want to make absolutely clear, although I think it is that we never ask the trial judge ever to reconsider anything. We ask him once, and only once, to vacate the order he had entered without notice to anyone, or without notice to us. I guess it was notice to the governor. But so when he did that, and when you said no, then we went back and asked him to vacate it. And when he refused, here we are. The holding of Babb, and it was done without briefing, and it was done on the petition alone, and the record, which consisted of the affidavits and so forth, was that prohibition was appropriate. They entertained prohibition, and they denied it on its merits without any response from the state. I do want to address two things about the statutes, and then I'll answer whatever questions. One of the best ways to look at this is the way that Judge Maker from the first DCA, who was Florida's last last Solicitor General, did. And he said quite clearly, in a case in which he concurred, and this is the case where the state attorney, Mr. Meggs from Tallahassee, was objecting to the trial court asking his lawyers to prepare jury instructions. And he said, wait a minute, my lawyers are executive branch officers. You're a judicial branch officer. You can't order my folks to do anything. And that went to the first DCA. And Judge Maker concurred in the decision that, oh yes, you can, because they are both officers of the court, obviously, as are we, and officers of the executive branch. And he quoted from a federal case, I'm not sure why, on separation, but he endorsed this phrase: a statute or practice imposes on an officer of one branch a duty, when a statute or practice imposes on an officer of one branch a duty that is unrelated to the central mission of that branch, that would lead to separation of powers problems.
But it seems to me that if a lawyer is an officer of the court, and we have an integrated bar that's under the jurisdiction of the court, that if there is a situation in which someone is constitutionally entitled to a lawyer, and that lawyer has to be appointed, from the separation of powers, it makes more sense for a statute to have the court appointing them than someone else.
Well, I'm not sure it makes sense in the scheme of efficiency, because now it's done by the clerk, but...
I mean sense from a constitutional standpoint.
I see what you mean. Well, but the function that the court has to ask the lawyer to do is a function that the court does, not some other function. And one of the ways to look at this is, how would you feel if the legislature decided that some other executive branch hearing process needed lawyers to represent the parties that appear before it, and the legislature appoints passes a statute that requires the court to appoint a lawyer to represent someone who is appearing in a license proceeding before the Bureau of Barbers or cosmetologists or undertakers.
Well, if they had at least a constitutional right to that lawyer, why would that be bad?
Well, it would be bad because the court doesn't have anything to do with the license procedure.
But we have something to do with the control of lawyers. No.
But not of clemency.
It seems to me that it would violate separation of powers more if we had, the general, some representative from the legislative or the Attorney General's office, someone in a different branch of government, ordering the lawyer to appear and represent.
Well, it wouldn't be ordering them, you'd be hiring them, engaging them. The executive branch engages dozens of lawyers every month, and all over the state for various purposes. And that was one of the iterations of the Speedy Justice Act, or whatever it's called, that passed, since repealed, or since struck all by an amendment. But that was one of the versions, is that the executive Board of Executive Clemency would procure lawyers, hire them, pay them, and then they would do it. It doesn't have to be an appointment. It isn't a commandeering situation. One of the problems, speaking of statutes, is Florida Statute 924.051, which I just happened to think of, and Section 9 of that says, funds, resources, or employees of this state or its political subdivisions may not be used directly or indirectly to appellate or collateral proceedings unless their use is constitutionally or statutorily mandated. Now, no one would suggest this is statutorily mandated. It may be statutorily permitted, as Judge Galen points out, but it's not required by the statute.
You're about out of time here, so. Okay. That concludes our docket then. Of course.